you see American cases discussed in the Chinese press or on Chinese social media. And it's the same thing. That sometimes you have ideas about what's happening, but you don't necessarily understand the framework. You don't understand where some of these, some of the things you read about are coming from. So, what I want to do today is to give you the beginnings of a framework to understand American law. And so, don't want to make lawyers out of you, but to give you, help you understand the factors that shape criminal cases. And then you probably know this already, but when you read things, when you read something in the paper, you hear it on TV, you read it online, you're not necessarily getting the full story. Just because the person who writes it doesn't necessarily know the full story themselves. They do the best they can, but it's important to understand that. And then the other thing is, when you see something online, you have an emotional reaction. You see that somebody did something terrible, you know, to a child or a spouse or a friend, and you have a reaction. Well, why wasn't he sentenced to death? Well, there are reasons. So we're going to talk about some of that. And so, as I say in the last thing here, you know, sometimes think of the old adage that, you know, an eye for an eye, a tooth for a tooth. That's what justice is. Well, not necessarily. Not necessarily. So there are different things that the courts are thinking about. Sometimes punishment is part of it. Rehabilitation may be another part of it. And we'll touch on that. And so, in doing that today, we're going to talk about a few cases, two American cases and one Chinese case. And that will be our framework, because if I just talk about theory, you know, for example, what you're seeing now, you have no context. You know, it's hard to understand how things fit in. So, when we look at the way the American legal system is set up, we have to understand first about American government in general. The American government was created by the states. We had a revolution 200 years ago, and there were 13 colonies, and there was no central government. They had to make a central government, and when they made the central government, part of the reason, part of the thought that guided them was that they didn't want to give the central government too much power. So the U.S. Constitution has the guiding thought that these are the powers, certain powers, the states give certain powers to the central government. And the powers that the central government, other powers, the states keep. So the central government is a government of limited powers. And just a little bit more, in American schools we call this civics. The Constitution provides for 3 branches of government. You have the executive, that's the president, and the departments of the government. You have the legislature, which is Congress, and then you have the courts. So we're going to talk about the courts today, but that's the framework that we're working with. So when we look at the courts, we have federal courts and we have state courts. So again, going back to the central government was created by the states. So, but they're parallel. You have the trial courts, which conduct the trials. That's the first place that people go if they're accused of a crime. Then you have the Court of Appeals. If somebody's not happy with the decision in the trial court, they can appeal it to the Court of Appeals. And so you see it on the federal side. Then on the under the state side, there may be maybe more than one level of appeal. But then you have the Supreme Court. There's a state Supreme Court. There's the U.S. Supreme Court. And the state Supreme Courts are on matters of state law. They are the state Supreme Court is the final word on matters of state law, except for the rights that are given by the Constitution, personal rights which are given by the Constitution. Those can go to the Supreme Court. And we have a joke. It's like, and this is a play on the word infallible. And you probably know that infallible means that somebody is always right. They can never make a mistake. So here's the joke. They say that the U.S. Supreme Court is not the final court because it's infallible. They say that the Supreme Court is infallible because it's final. It's the last place people go. So that means no matter what they decide, that's what's going to control. So again, we're going to come back to these points, but I want to give you I'm giving you the framework first. Oops. So when we talk about the two court systems, this goes back to what I said before about the states creating the federal courts. State courts can hear anything, can hear all kinds of cases. They will establish courts that have more limited jurisdiction, courts that can only hear certain matters, like small claims court. Small claims court generally matters, disputes no more than $5,000. Or municipal courts for cities, to take care of offenses that take place in those cities. So, but the federal courts are courts of limited jurisdiction, and they can hear cases between the people from different states. Because originally, one of the things that concerned people, concerned the people who made the Constitution, was if somebody from Arizona goes to court in California, and he's suing somebody who's from California, maybe the California courts would say, well, he's from Arizona, it doesn't matter. So that was one reason they created. They call this diversity jurisdiction, because you have diversity among the people who are before the court. And sometimes, but by the same token, they don't want the courts to be flooded with, small cases. So there's a certain amount. If you're fighting over a commercial matter, you have to have a certain level of money that you're talking about. And then the federal courts can hear cases where there is a federal statute involved, a federal law. And that's one of the ones we'll talk about today. Now, I'm going to give you another concept now to sort of keep in the back of your mind. The American legal system is based on the English legal system. And in the English legal system, they use something called common law, where the courts over the years have heard cases and they've made definitions, they've decided, well, as they decide each case, this is the basis for future legal cases. So that the idea is that there's supposed to be consistency in the law. So that when a court hears a case, they're supposed to look at the decisions that have already been made, so that to make that decision to be controlled by the earlier decisions. And that's the way the common law works. So that over the years, when the courts heard murder cases, this is the general definition, the common law definition of murder. That one person kills another, they do it unlawfully, and they do it with the intention to cause death or serious injury. That's the base. Those are the basics of common law murder. But these days, the common law definitions may apply, or the state legislature may have made another definition. And this will vary from state to state. So you always have to look at the statutes in that state. But here are some differences that you see. That others to the statutes, the courts have, the legislatures have distinguished between different kinds of deaths, so that you have first-degree murder, and that involves premeditation. You had to think about it. You had to plan this in order to do it. Then you can have second-degree murder, and that is that perhaps you weren't planning to kill somebody, but the actions were with reckless disregard for human life. So the person, they just went ahead with what they wanted to do, and they didn't care whether it was going to result in somebody's death or not. So that's second-degree murder. Then you have manslaughter, and you can have voluntary manslaughter, or you can have involuntary manslaughter. So that voluntary manslaughter, generally speaking, it involves the killing of another person, but this happens during a sudden quarrel or in the heat of passion. Man walks in on his wife, with another man, heat of passion. So the idea there was not that killing, death wasn't necessarily intended. It wasn't intended, but you had these circumstances, and it took place in that during that. Then you have involuntary manslaughter, where the killing was not intended, and a person was how can I say, they committed a minor crime. It took place during a minor crime, a misdemeanor, or it was, again, reckless conduct during legal activities, and this resulted in somebody's death. So you see how the courts, the legislatures start to distinguish between kinds of death. And this goes back, I think, to the larger question when we talk about what is an orderly society? How does society order itself? So, the courts are intended to provide guidelines for the conduct, for people's conduct. And let's go back to the idea what we said before. An eye for an eye, a tooth for a tooth. Somebody dies during some interaction between people. Does this mean that every time somebody dies, you know, the person who was responsible on the other side has to die too? And I think when you look at these different definitions of different types of homicide, you know, the death of a person, different kinds of homicide, it shows that society, through the legislature, the people who make the rules for society, have determined that, no, there has to be, it has to be recognized that there are different circumstances. And this is an effort to deal with that. And when we look at these particular cases, we'll see that, you know, when people, you know, it gets messy. And, you know, and the courts have difficult issues to deal with when there's been a death, and they look at everything that's involved. So, again, this is something else to keep in mind. Okay, so we're going to talk about 3 different cases. And each of them, there are things, each of them illustrates something that that I've mentioned to you already. It gives you an illustration. So that we have a federal case from Illinois, we have a Texas case, and a Chinese case. Now, we're not talking about American law in Chinese cases, but it's interesting for comparison. And so the first case, the Illinois case, that involved a Chinese student who was abducted and killed from the University of Illinois. And her name was Zhang Ying. And it was interesting. Now, what's interesting here is that I read about this case in the China Daily. And apparently, this is a very good story. They were very thorough. And they said that the case, well, it got a lot of attention on Chinese social media. And people in China were paying a lot of attention to it. So did anybody hear, this was several years ago, does anybody hear of that case?
Yes. Yes.
Yeah. Okay, good. So then, good. So you'll have some understanding of what I'm talking about then. So the case was like there was. So if you look at the screen here, you see they gave a very detailed chronology of what happened during the case, and it was it's helpful. Because they put a lot of effort into explaining what happened. But I'm just going to highlight some of the main things that we'll talk about. So, interesting thing. This case was in federal court. And generally speaking, if you're talking about murder cases are not generally going to be in federal court. They're going to be in the state court instead. But this person was charged with kidnapping. It's a federal crime. It's a state crime. And so that's how it ended up in federal court. And we'll talk some more about that as we go along. Now, in this case, the federal prosecutors indicated that they were going to seek the death penalty because ultimately the charge was that kidnapping that resulted in death. So that federal prosecutors were seeking the death penalty. On February 11th, 2019, there was a request from the defense to exclude some DNA evidence and blood test results that had come up during the investigation. And as I go through this, I'm going to highlight certain aspects of federal law, or criminal law generally. Basically, there are two parts that show up, two elements that show up in the criminal law. One is the law of the prosecutor's law, proving the crime that happened. But in the Constitution and in elsewhere in law, you have protections for the defendant that are built into the law. And when we talk about evidence, that's one of those. There is, for example, if evidence was, the police obtained evidence illegally, that evidence is going to be excluded. It's not admissible. The police cannot break the law in order to prosecute an offender. So in this particular case, the court found that this was evidence taken from the apartment, that it met the admissibility criteria for admissibility, meaning it could be used. Now, next thing, on February 29th, and this got kind of cut off, the defendant's lawyers said they were abandoning the mental health defense. Not clear what exactly that was. My guess is that they weren't going to, and they didn't claim that he was insane at the time. And that is a recognized defense in the criminal law, that somebody was insane at the time they committed the crime. But here they said no, they weren't going to do that. Go ahead to June 12th. So this is kind of interesting there. So the defense attorney admits that he killed Ms. John. And the federal prosecutor gives more details, which are pretty bad. That he raped her before choking her for about 10 minutes while she continued to fight for her life. The next entry on June 17th, they showed his online history, and that he wrote considerably about fantasies about abducting somebody before she disappeared. Go ahead to June 19th, bottom of the, pardon me, top of the last column. And there's a witness, this is his former girlfriend, who says he spoke to her about being able to kill somebody and get away with it before Ms. John was abducted. And then her testimony continues, and say he bragged, he boasted about her death. Now, this is another protection, is the hearsay rule. The first time, there is a Chinese word, "ting shuo," kind of the same thing. You heard somebody say, something, and the rule, or they're not all. Hearsay is limited. You can't use all kinds of hearsay. In this particular case, I think there's an exception that applied. They call it an admission against interest. Somebody says something that is not good for him. And the fact that when somebody says that can be used, even though it's hearsay. So that's my guess there. So look at June 24th, he's found guilty. kidnapping and killing John. So the jury has to make a decision about the penalty. And the rule was that it had to be unanimous. So they had a 12-person jury, and they couldn't reach a unanimous decision. So the death penalty was not possible under those circumstances. So in the end, the sentence is life in prison without the possibility of parole. So goes to prison, and he's not going to get out. So what are some of the things that happened in this case? Why was it a federal case? Well, it was a case, first of all, in federal court, first of all, because there was a federal statute, the kidnapping statute. There is a question here, and I don't want to burden you with too many details because I don't want to confuse things, but ordinarily, when there's a federal statute, it would involve something happening over state lines. And I honestly don't know whether the federal charge was possible. I'm not sure where the interstate connection was. She didn't go across state lines. He didn't carry her across state lines that we know of. The fact that she was an international student, maybe that made a difference. So these are questions, and I would imagine this was argued at one point. But so that was a question. The other question is, so we look at the role of the jury, and this was something that was criticized in the Chinese social media. Why do you have a jury made up of non-professional people? They're not experts in criminal law. But one of the principles of Anglo-American law is the idea is that a person is judged by a jury of his peers, people like him, so that again, this is a protection for people. They're not, well, the English expression that comes to mind is they're not railroaded. And by railroaded, we mean that it's kind of like they're put on this track and they just have to go where the track goes. But I will tell you, it also happens sometime that it's fairly clear that a person is guilty of a crime. But the jury, in its deliberations, decides not to convict the person. And the principle here is that the term we use is jury nullification. What it means is the jury decides that it's not just to apply the law in this case to find this person guilty. So that is a principle of Anglo-American law, that you have to have a jury of your peers. One of the things that happens in jury selection is that both sides, in choosing jurors, they try to determine if there's going to be any prejudice, that person has a prejudice towards one side or the other. And when a jury is selected, both sides can say, ask the person, something about their background, whether they have police connections, law enforcement connections, whether they know anybody in the case. And then they can say, no, we excuse this person, we don't want this person on the jury. So in the end, you have a jury that both sides have had a chance to ask questions to the potential jurors. Then we get to death penalty questions. Maybe you know this already, but the death penalty is a matter of considerable controversy in the United States now. I think there are about 21 states that have abolished the death penalty. And there was a ballot question in California within the last few years about the death penalty and whether California should abolish it or not. And so it's, as I say, it's a matter of considerable controversy. The other thing, it's a practical consideration, it's not really a legal consideration, is that basically every death sentence gets appealed. And in most cases, I think that's a matter of law. That the law says there shall be, there will be an appeal taken for every death sentence. What this means is that it takes years before a death sentence can be carried out. And actually, when that California ballot question came up, I voted against the death penalty because it just seemed to me that after a while, the state spends so much money in the appeal process. In the end, if a person is sentenced to life imprisonment, that is not a bad result. But this is not a settled question. People have different opinions about this. So, let's see. So the other thing on the death penalty, like the requirement is the requirement that the jury be unanimous. So it's another protection. And you can disagree with it or agree with it, but that's the purpose for it. And this issue has been around for a long time. So the arguments have been made on both sides, and a lot of people have their minds made up, but people are still arguing. So that's what we have there. Okay, now we're going to look at another case. This is the one from Texas. And this took place, in the facts of this case, this took place in a remote ranch in Texas. And in that case, the father heard, somebody told him that somebody had carried his daughter off. And the father found this man, Jesus Mora Flores, he found him raping his 5-year-old daughter. So he pulled him off the child, and he inflicted several blows to his neck and head. And he didn't intend to kill the guy. As a matter of fact, when he saw that the guy was pretty seriously injured, he called 911. And he's trying to tell 911 where the child, where they are, because this is a very remote area. And they can't, the emergency personnel can't find it. So, and his father's getting more and more upset, and he says, this guy's going to die on me. And then he tells the dispatcher he's going to put the man in his truck and take him to the hospital. So, and he died. But And the girl was taken to the hospital, and she was examined, and it was confirmed that she had been sexually molested. So this case, the police didn't believe that he should be prosecuted, and when the grand jury heard it, they agreed. They did not decide to bring charges against him. And the reason was that, remember what we said before, that, you know, in common law, first-degree murder was an unlawful killing. And the grand jury decided that he was authorized to use deadly force to protect his daughter. So there was no unlawful killing. And that's why they decided not to indict. In indictment, that's the term we use to explain, to describe a decision to bring charges. It's not the same as a conviction, because when a person is convicted, there's a standard of proof that has to be met. And the standard of proof is guilty beyond a reasonable doubt. If there's a reasonable doubt about something, the person can't be convicted. But for indictment, it's only probable cause. Is there enough evidence that a crime was committed? That's enough for an indictment. Then the case would go to trial, and then the decision is made as to whether there's proof beyond a reasonable doubt. So that's a state case, and you know, it's just a parallel. It's, you know, this is a parallel proceeding to a federal. You know, you saw how the state courts and the federal courts line up. It's parallel to that. So let's see. There you go. Let's jump ahead, and then we'll come back on the to talk about the Chinese case. So, question: why wasn't the father charged? Because the grand jury believed that there was it was not an unlawful killing. The father was authorized to use the deadly force. And then we talked about the role of indictments. So now
I have a question.
Yes.
Is there a prosecutor involved to bring the case to the grand jury?
Yes. Yes. Generally speaking, the prosecutor is the one who presents the case to the grand jury.
But the police, they decided to charge you?
Well, you see, the police can make recommendations, but it's the prosecutor's role.
But the police will present the case to the prosecutor?
That's right. Police present it to the prosecutor, prosecutor presents it to the grand jury. Right. And actually, I hesitate to say this because I don't want to give you the wrong impression, but I will. There's another joke. It's a joke among prosecutors that you know. You see, the prosecution, you know, the prosecutor is very persuasive before the grand jury, and the joke is that you know, the prosecutor can get the grand jury to indict a ham sandwich. You get it?
Okay.
Ham sandwich.
Yeah.
But in this case, he failed. He didn't get it.
Well, you know, the police had decided, in this case, the police had decided that there was, you know, it was a lawful use of force there too. So it's not a case here where the prosecutor was trying to get the guy indicted. But as a general rule, it is easier to get an indictment because it's a lower standard of proof. You know, is there enough evidence to bring charges against somebody? and the real test in any case is, you know, if a case goes to trial.
So if the grand jury indict the case, then it will go to trial?
Right.
Okay.
Right. And you see, the thing, let's see. You see, in the grand jury, there's no defense attorney. But if there's a trial, there's a defense attorney. Because the only purpose of the grand jury proceeding is to decide if there's enough evidence to bring the charge.
But in that case, it sounds like a one-sided story.
Well, it is. It is. But I mean, there's no determination of guilt that's going to come out of a grand jury proceeding.
It just determines whether this is a case.
That's right. Whether there's enough to go to trial.
Yeah.
Okay? Okay. So here, just a second.
A question?
Huh?
Yes, a question.
Yes.
So how do you draw the line between, say, self-defense versus excessive use of force? See, this guy could just cause damage to the other guy. The father could cause the damage instead of killing him.
Well, you know.
And then
Go on.
he's not in danger of, himself or his daughter will not be in danger of this guy, right? So how do you draw the line?
Okay, I got lost there somewhere. I'm sorry.
Okay.
So I think you are referring whether self-defense covers the case defense for the other person.
So why this guy is not guilty? He killed the other. Of course, everybody liked his outcome, right?
Right.
But he killed the guy instead of just cause enough damage so the guy is not able to come back and fight him.
Well, I tell you, self-defense can be a defense against these homicide charges. But in this particular case, let's go back to the definition of, the common law definition was an unlawful killing. And the grand jury and the police believed that the father was justified in using that force to protect his daughter. If let's say there had been an indictment, let's say that it had to go to trial, then in that case, they might charge. They might charge first-degree murder. Remember, let's go back to our definitions about reckless disregard. Maybe they could charge first-degree murder. They could charge second-degree murder, saying that he was, he used more force than was necessary. Or maybe, let's remember the definitions of manslaughter. Where was there too much force used under the circumstances? These would all be questions for the jury in a jury trial. That answer your question?
Yeah. So sometimes it's hard to draw the line.
Yeah.
There's
Well,
no clear cut.
Well, it might not be clear cut. Well, it depends. Depends
Right.
where you are, whether you think it's clear cut or not. But in a jury trial, everything can be argued. So the prosecutor would say, yeah, it was justifiable force. The defense attorney, so I get turned around here. The other side might argue, it was not justified, and that's where the jury has to make the decision whether it was a justifiable force or not, because in the Anglo-American system, everything, it's an adversary system. the idea is that both sides will argue the points that they want to make, and in that way, if you figure that each side will make the best argument it can make, the truth will come out in the end. But in the end, it's always a hard decision, no matter what issue you're talking about.
I also have a question.
Yes?
I don't understand, like, seems to me like always the jury always choose between two options. Take an example of the Ms. Zhang's case, they choose between death penalty and the lifetime prison, right?
Yeah.
So why is these two options? Like why not like death penalty and 50 years in prison? Like what makes them like finally they deliberating between these two choices?
Oh, well, the jury does not have, the jury is not responsible for all decisions. So, in this particular case, the choice was unanimous decision for a death penalty, but the fallback position was life in prison with no, no chance of parole. Generally speaking, it's up to the judge to decide whether it's going to be, how long a sentence is going to be, because the way most statutes are written, it could be 20 years to life. Maybe the penalty shall be imprisonment for 20 years to life, and the judge has to decide whether it's going to be 20 years, 30 years, or life. So that's the way that there's a division of labor there. Okay, now let's talk about our Chinese case here. And this is here. In the end, this guy, Zhang Koko, was found guilty and sentenced to death by the Chinese court. And it's a messy case too. This case goes back, really started 20 years before. His mother got into an argument with some neighbors. I think the neighbors were passing out watermelon and they passed her up, and she got unhappy about it. During the argument, she pulled out an iron rod and hit one of the neighbors. Well, the neighbor, who was 17 at the time, hit back, and she died. So there was a trial, and that neighbor got a 7-year sentence. There were a few reasons. I think the primary reason was that he was only 17 at the time. Also, they felt that the court there felt that the victim, the mother, had contributed to the argument, or provoked the argument, since she threw the first blow. And then, as part of that sentence, I think it was part of that sentence, the family had paid certain compensation to the mother's family, 8,000 RMB or something like that.
I don't think so. At the end, they didn't pay nothing. That's why one of the things made him free.
I'm sorry, say it again?
I don't think at the end they did anything to the young mother. They didn't do it. They didn't do it. And that's one of the really angerness that Zhang Koko he have in the time period.
Okay.
So
okay.
they never apologize. They never ever give any compensation to the family.
Okay.
But did the court
Even they-
decided to
Yeah,
ask them to
whatever
make
they
the
said, but they didn't. At the end, they didn't. That's make him from the childhood. He decided not go to marry, not go to school. He planned for it.
Oh, well, okay. thank you for that information. But the only thing I would say, I mean, I'm not making things up here.
Right.
I'm only saying what's reported,
Right,
you know,
right, right,
in the
Very,
one,
very
yeah,
interesting case.
one Chinese website, one, you know, South China Morning Post.
Right.
So, but this goes back to what I said before about the limitations of news reports. You know, sometimes you don't get, you know, there's stuff that's not there.
Right.
So, but thank you, yeah. So anyway, so, okay, so you know this already. So in 2018, you know, Zhang and the man who had served the 7 years both go back to their village for the Spring Festival. And Zhang watches as the family goes to, you know, visit the family's tomb and sweep the tomb. And then afterwards, they're coming back. He approaches them. He stabs the man who killed his mother, the brother, and then he goes, apparently the father wasn't with him, then he goes and finds the father, stabs him, then he throws gas on the family car and burns it up. So that was, you know, so, oops, just a second. So, now the interesting thing, there's more history here. It's kind of interesting. You know, Zhang had sort of kept this, you know, he had waited a long time for his revenge. He went into the army, and apparently he told people while he was in the army that he wanted to make himself strong so he could get revenge. And he had an online, he posted stuff online too. You know, kind of like our guy in Illinois. And so, and apparently, the things that he said were reported to his superiors in the army. And he had, I forget what the expression he had some sort of session with his superiors that they were trying to sort of get him off of this. But when we look at the two cases, the Texas case and Zhang Ko, there's an element of premeditation there that, you know, certainly did not exist in the Texas case. And so, and there's more you can point to where the Zhang Ko had, he told people what he wanted to do, he posted stuff online, which is actually a lot different from what the father in Texas did, where, you know, when he saw what he had done, you know, he's doing what he can to keep the guy, you know, to save the guy's life. He calls 911, you know, saying, you know, stays with the 911 dispatcher, just, you know, where are you? What's going on? Finally says, I'm going to take this guy to the hospital. So, I mean, bad result in you know, in the Texas case where, you know, the man died in any event. But it was a lot different, I think, than Zhang's case. So, let's see, okay. So, I wanted to read some of the things that came out that were reported in the China Daily. So one person wrote on Sina Weibo, he didn't show regret at all, not even an apology. How can we expect him to have a conscience? We still have no idea where Zhang's remains are. Did the murderer get away with death simply because of the jury's humanity? Isn't it supposed to be a life for a life? Are they still looking for some goodness in the murderer? So disappointed. Just a second here. So there was a Facebook post. There was a Justice for Ing page, and this poster said, "People like Christensen and serial killers who show no remorse, no emotion, should simply be put to death and forgotten. Instead, they're glorified in some movies, such as Ted Bundy and American Psycho, where they look awesomely evil." Okay. Actually, as regards that, there is a law called the Son of Sam law. And there was another killer years ago called Son of Sam. And what he did, he went to prison, and then he wrote a book. And I don't know whether there was a movie or not, but basically, you know, he was making money off of his actions. And this law was passed that said, no, a criminal cannot profit from his criminal actions. So you see these things that happen, like, you know, Ted Bundy or the movies, and there is no perfect solution here. But these cases underscore how difficult the questions are. And I think people are always looking for ways to improve the system. But, you know, take a look at Zhang's case. The court had its reasons for sentencing his mother's killer to what looked like a very light sentence. And I think in the United States, we can set aside the questions of compensation for to the family, but I mean, it's highly unlikely that a 17-year-old would be executed in a similar case. So, yeah, sir.
Yeah, I think I read somewhere, the story is a little more complicated. It's just the brother, you know, there's an elder brother who also participated in the fighting. So the elder brother was the main guy, and because they knew somebody in the system, right? They said to the elder brother, certainly the elder brother will be put to death. So they swapped the person. I'm not sure if it's true or not. That's what I read online.
You're absolutely right, and that was this on the one website here, Sixth Tone.
Okay.
That was mentioned in there. Yeah, that's it. But the court can work only with what's in front of it.
Right.
And you know, if there are questions of corruption in the court system, well, you know, you have to have evidence of it in any event. But you're right. You're right. Good point. Yes.
Okay. Let's talk about, you know, the American culture here. I've been living here for 30 years.
Okay.
Okay. I've been a professional for over 25 years.
Okay.
I also went to a few jury elections in Santa Clara County.
Mm-hmm.
So I have a lot of feeling about the U.S. court system here.
Okay.
Let's give you my feeling here. In a lot of cases, I read a lot of news every day. It's been my life. I like reading those news. Mm-hmm. The court system, I'll give you an example. A lot of first-degree murder cases. If the alleged killer could find a good lawyer, or he comes from a wealthy family, so the family could hire a good lawyer, then the lawyer could take advantage of the knowledge of the law and trying to help the alleged killer. For example, in case this is a first-degree murder, then they could reduce, you know, the allegation from the first-degree murder to the second-degree murder, or help the alleged killer to reduce the sentence. So this is a pretty much a very common culture in the country. So how do you feel about that, based on of your many years of the judge, being the judge in the system?
Well, you know, in general, I agree with what you're saying. That, you know, if a family has money, they can hire a better lawyer. But that aside, lawyers will always try to justify or explain away something in order to minimize what their client has done. There is another factor here that the system is swamped with cases. You know, there are too many cases. If people went to trial on every case, everything would grind to a halt. So what happens is, you get a good lawyer, maybe even a not so good lawyer. There'll be a plea bargain. They say, let's save the cost of a trial if you plead to second-degree murder instead of first-degree murder. And then justice is sort of done. And we don't have to spend money on a trial.
Right.
So in general, I'm not disagreeing with anything you say. But
So does that serve the justice of the crime?
Well, it depends. I don't want to say it's all relative, but I mean, here's the expression that comes to my mind. You know, is the perfect the enemy of the good? Do you have to have absolute justice in each case, or sort of a lesser form, or less, I hate to say less justice,
Right.
but just not as much as you would like, but something. It's, you know,
So is it in general, the best defense lawyers are always better than the prosecutors? In terms of experience, in terms of,
I think it's hard to generalize. I don't think you can say that.
At least they get paid more.
yeah,
Well, I mean, you know, I tell you what, the ones who get paid more you know, they've had good results. They have a track record. And then, yeah, I mean, that's sort of what it boils
I
down to.
actually have another question about the earlier slide.
Yeah, sure.
Is it true that in a lot of states, killing a police officer on duty is always prosecuted as first-degree murder?
I'm sorry, is always prosecuted?
As first-degree murder.
Actually, I don't know. I mean, it's serious enough.
But is it worse than killing a regular person?
Yeah, it's
Like no bank robber will plan to kill an officer unless the officer arrives.
Well, but actually, I didn't, when I gave the thing about first-degree murder up there, I focused on premeditation. But I looked at the California statute, and actually, there are other factors which will contribute to a first-degree murder charge, like the use of certain weapons. You know, will be a first-degree murder charge, and I don't know whether, say, you know, the death of a police officer would fall. There's something called the felony murder rule. And the felony murder rule says that if somebody dies during the commission of a felony, that's first-degree murder. So, you know, maybe what you're talking about falls under that. But bottom line, you know, it's complicated.
Wow.
Yeah, sir.
Everybody knows when the argument in the court, both sides have their own fact and reason, right?
Right.
But if the one side have a strong lawyer, but the other side doesn't, so usually the judge will be listen the other side. So that is not justice. So how do you think the American system can use some way to ignore this problem or effective justice?
Well, yeah, it's a hard question. No, I mean, it simply is, because, when I was working, I was an immigration judge. I was not dealing with murder cases in immigration court. And I always, people would come into court and they say, oh, I can do this by myself. And I would say to them, no, I don't think that's a good idea. So, I mean, I pushed them to get an attorney. Well, sometimes they would come back, and not all attorneys, there are good attorneys and attorneys who are not so good. And they would come back with an attorney, and I said, well, he has an attorney, but it's, wouldn't be my first choice. In those cases, I made sure that everything, well, I couldn't really influence the case. But I mean, it's not that I still, worked to make sure that there was the respondent got a fair hearing and had the opportunity to say what he wanted to say. Now, the fact was, in some cases, a good attorney would have done more with the facts of the case. But I couldn't do much about it. The question here is whether the judge's sentence may be appealed.
Yeah, maybe appealed by the prosecution, not by the defendant.
I understand, but when I talk about we talk about an appealable issue, and the short answer is, I don't know whether it's an appealable issue. I've never heard of it. Now that you mention it,
I have never heard of it either. So that's my impression. It's not appealable.
Maybe I'd have to look at it. And
so, in your opinion, is this a good system to allow for prosecution protest?
I don't think it's necessary.
I'm sorry, can you repeat it in Chinese? I don't know what that means, some of the words.
Even if I say in Chinese, you may not know. It's called 抗诉，检察院抗诉。也就是说，如果法院量刑过轻，检察院可以向上级法院提出抗诉，要求上级法院处以更重的刑罚。比如说，韩国的一个海难的船长被判36年徒刑，检察官抗诉的结果是改判无期徒刑。在日本也发生过从有期徒刑改判死刑的。Okay, I'm explaining.
Yes. So let's have a simple question, right?
Sure.
How do you find the right attorney? Like you said here, some attorneys good, some are bad. What's your recommendation? Where to find the best attorneys? Affordables.
No, I'll tell you what. In the immigration context, there are only the way I kind of thought about it was a lot of people who come to immigration court know other people who have come to immigration court, and they should talk to those people and find out what their experience was. Did the attorney answer their phone calls? And, well, did the attorney get a good result? If they're still around, did the attorney get a good result for them? Now, if you're talking about, ordinary people in an ordinary criminal case, it's harder, I think. because, you know, I don't think most people, you know other people who have, you know, had criminal cases. One way is to see whether the attorney had complaints against him at the state bar. You know, they all have to get a license from the State Bar of California to see whether there were complaints. You know, a lot of attorneys advertise, but I don't know whether that's the best. I don't think that's the best way, you know, to find a good attorney.
How true are the billing rate? Some attorney bills twice as much as the
Well, that's
regular.
true.
So, yeah.
That's true. You know, some attorneys bill a lot, but actually they get good results.
Same like your contractor, your business.
Right. There you go. There you go.
There you go.
Yes.
Did you see the movie called Liar?
Good liar?
Yeah, Liar, 叫 the movie, the title called Liar, talk about a lawyer and his
Oh.
son and said you don't lie.
Did you say lawyer or liar?
Lawyer?
Lawyer.
Liar.
Liar, the
谎
movie.
言对吧？
It's a
一个
movie.
电影叫《撒谎者》，讲那个小孩儿他生日的时候许愿，说让他爸爸给撒谎了一天的事儿。有没有人看过这个电影？那个电影就叫《Liar》。
You know, I don't think I did.
Oh, okay.
Yeah.
But
So,
so my question is, many lawyers are liars. So in America maybe it's a common thing.
Yeah.
let's,
I have the case and that somebody is perjured. So I want to hire a lawyer to sue the perjurer. And the lawyer told me in his 30 years experience, just say the 2 cases when the perjurer. He said, yeah, like
okay. So perjury, you mean like lying under oath?
lie on the court.
Yeah.
Yeah, right.
Uh-huh.
Right.
So,
Okay.
And
So, okay, go on.
so how can I sue the liar?
Last thing you wanna do.
Well,
And sometimes the lawyer have his client to lie. For example, make some document.
well, you know, there is a practical side to these questions. And it's like somebody, I don't know, if somebody felt they were discriminated against. Somebody, you hate to say it, but some cases it's going to be hard to find a lawyer to take. It's going to be hard to find a lawyer to take that case. Maybe there's, in terms of the legal system, it's sort of, it's a smaller case. There's not that much money involved. Or a person says, well, I want to make a point, you know, that people can't do this. Well, that's not usually going to be a good case to take to court, because we were talking before about how overburdened the system is, and some cases are going to fall into a category where nobody wants to do them because there's no, for other people, for you know, not for the person who wants to bring the case, but for other people, there's not that much involved. Not a satisfactory answer, but I'm afraid that's the way it is. Yeah.
One more question.
Sure.
I have 2 questions. So, there is a doctrine in the U.S. legal system called fruit of the poisonous tree, meaning if evidence is gathered using unlawful means, the evidence can be thrown out. Earlier, in the Zhang Ying case, you also mentioned that the defense attorney initially requested to throw out some DNA evidence, and the federal judge denied that.
Right.
So this doctrine actually is unique in the United States. I once read an article on New York Times. It's a series of articles about American exceptionalism.
Okay.
It mentioned that the doctrine of the fruit of the poisonous tree is unique in the United States. In other countries, like Europe, for example, where it's also considered to have a very fair legal system, such evidence can be admitted, but the police officer or whoever who gathered the evidence using illegal means would also be prosecuted or be punished in the civil court. So they have other remedy and other means to penalize those who gather the evidence unlawfully. But the evidence, once gathered and validated, is still admissible in their legal system. That resulted in more efficient court system, the more efficient trial. So that New York Times article mentioned that the United States is the only country in the world probably that has this doctrine. So in your opinion, is this doctrine really a good one or not?
So you're talking about the exclusionary rule?
Yes, if the evidence is gathered.
Oh, as long as I didn't get the term, but
Yeah.
the exclusionary rule, okay. Yeah, if evidence is gathered illegally, it's not going to be, admitted. I think I would say this, that you mentioned some sort of showing that it was more efficient to do it the other way. And if there was a study to that effect, I'd kind of like to see it. Because I mean, I think if there's a showing that there are more efficient ways to get better results, then we should do it.
I think the only thing I know is about Japan. I don't know about other countries. Japan usually is considered to be extremely efficient in the legal system. I can't say for other countries.
Okay. Well, then you see, then we get into the question of common law systems versus civil law systems. And Japan is not a common law country.
Yeah, sure. So it's not easy.
So I think that would be a hurdle
Yeah.
to get over. Because then you have, it's like, this is the way we've always done it, you know.
So we should study the United Kingdom.
Well, I mean, that's a common law system too.
Yeah, that's
So,
later.
right.
Yeah, I got a question.
Sure.
So, this is a little personal. So, why do you choose to be a judge rather than a lawyer?
Oh,
What motivates?
now, you see, and this goes down, see, as I understand it, in China, for example, people go to school to become a judge, or they go to school to become a lawyer. That's not the way it is in the United States. In the United States, everybody's a lawyer. And then certain lawyers become judges. But with that background, to answer your question, let's see, by the time I became a judge, you know, I had been a lawyer for almost 20 years. And I was ready for something different.
Do you need an extra qualification to become a judge?
Well, the most basic qualifications are simply admission to the bar and a certain number of years as experience.
As lawyer?
Yeah. 3 years practicing law. So, you know, by the time I became a judge, I had worked in a number of different positions, and I had done, had experience doing different things at that time. It was mostly within the immigration system, so that I figured I could be a good judge because I had seen a lot of different things over the years. And again, you know, let's say, you may find this in your career. After a while, you want to do something different. That's all. Yeah.
Another question?
I'm sorry, question here first.
Yeah, so do you have to have a special personality to be an attorney? Some people say, well, you got to think this way, you got to be naturally born to be something. How true is that?
To be an attorney, you say?
Yes, how true is that?
I guess yes and no. I mean, yes, in the sense that there is, when you're in law school, they tell you, you're learning how to think like a lawyer thinks. And there's truth to that you need to be able to analyze cases, because, in our system, everything, much depends on case law, so you need to be able to analyze the cases and talk about, and so how are the cases similar, how are they different? If you find a case that is exactly the same facts as yours, work with that, and then the lawyer's job is to make distinctions. So the lawyer on the other side looks at this same case that has exactly the same facts. That lawyer's job is to look at it and say, oh no, it's not. This is different and this is different, and so forth. So you have to do that. Beyond that, I wouldn't say you have to have it. Some lawyers are more argumentative than others. Yeah.
First of all, Robert, thank you for coming to Wu. You give us the show, the talk over here. Actually, I have one question also, a little bit similar related to your question. So, good to know you was the attorney before. So, what if, I don't know, you have been into the case that that is ethical, this is wrong, but this is my client. I need to defend him as my client for fiduciary, even he's wrong and he's right, because he's my client. So how your mindset was that time that this case is physical, okay, ethical is wrong, but I need to make it right. I need to defend him as my client. Because he's my client, my job as an attorney, I need to be fiduciary and work for him. He's right, it's my right. Right? So, but at the same time, like ethically, it's wrong.
Ethically, what's wrong?
That's my question. That's just you said. It's nothing wrong, right?
No. I said, you said ethically it's wrong.
Like,
I'm asking you, right? What's wrong?
This is a very clear case. He's a killer. He's a raper.
Oh, you mean, okay.
Right? So,
he committed the crime.
Right? He committed the crime, but at the same time,
First
he's
degree
my
or second
client,
degree.
right? He's my client. So I need to defend him as a lawyer. But as a lawyer, that no matter he's wrong, he's right. He's right is my right.
Well, it's like this.
How the conflict you having in your mind, that's more interesting. I know based on the bill you need to make him right, but based on consciousness, he's wrong.
Well, okay. I'll say first, I was never a criminal defense lawyer, so.
All right, that's good.
Okay. But I mean, you will hear all defense lawyers say that, the defendant is entitled to a fair trial. And what that, in its purest sense, I think, that means that if the state makes the rules, the state has to follow the rules. So, we were talking about the exclusionary rule about evidence before. So, if there is, if evidence was obtained illegally, then the defense attorney is going to try to get that evidence out, keep that evidence out, by arguing that it was obtained illegally. It should not be admitted. And if that's the difference between a conviction and an acquittal, well, the defense attorney has done his job. Then another thing the defense attorney will try to do, it's like in the Zhang Ying case in Illinois, when it came to sentencing, the argument, the defense attorney was arguing, well, I mean, he had substance abuse problems, he had this problem, he had that problem, therefore he should get a lighter sentence. So I mean, yeah, there are ways to be ethical about it. I think there are attorneys will argue, right up to the point where, probably if they go any further, they're not being ethical, but they'll try to push that as far as they can. But in its simplest terms, I think what I've outlined for you are things that attorneys are expected to do. It's their job.
Yeah. So still based on the book, before you think about the intention, all this I'm hearing from you, Simi, and the feeling, the expression that I'm based on the book. I do my job. This is my job. So it seems like less emotion attached to the case. That's what I hear from you. It's like, okay, this is both how that work. It should not be, okay, this is a wrong thing. I should not do it. Because you have to do it. You're a defender lawyer. You have to do it. He's a murderer, but he's a lawyer. Until he proves he's wrong, he's still right. Right?
Well, they have to be convicted beyond a reasonable doubt.
That's really need a very strong like a personality to handle that, because you really need to like stay behind all this without to get involved. Oh, I'm helping a guilty person that's defending him. You cannot have that mindset then, right?
I think that I can't quantify this, but I mean, attorneys do recognize that, yeah, their client is guilty.
Right.
But their job is to make sure the client gets a fair trial. That, you know, like I said, the state makes the rules, the state should follow the rules. If evidence was obtained illegally, it shouldn't come in.
I respect that.
Yeah.
Yes.
That's it. Yes.
Some position of the judges are elected, right?
Yes.
What kind of judges are elected? Like immigration is not, right?
No, no.
Yeah.
No. Well, let's see. Well, federal judges are not elected.
Even the state one.
State, it varies. It varies.
Huh? Because I always, like in the ballot, suddenly you have this judge, you need
Yeah.
to, so it
Yeah.
confusing.
Well, no, I mean.
Some judge got elected, some judge are not, so what
Well,
makes
it
them
works this.
elected or not?
Google it, Google it.
No, well, in California, how can I put, the general rule is that judges are elected, but if there's a vacancy before an election, the governor can appoint a judge to that position, and then the judge runs at the next election.
So it's not all judges are elected, right? Some judges are not. Is that right?
Well, I mean, some judges may not have been elected initially, but they all have to stand for election at some point, and that's true even for the California Supreme Court.
Because, the reason I ask because if many of the judges are elected, it means that there must be many judges in California. So in the ballot you should have a lot, but it's not. Even in the ballot, it's only like 1 or 2 positions or judges,
Well,
or even 1. So I was wondering. I don't know what's going on.
well, maybe nobody ran against the judge. The judge has no opponent.
Oh, and then it will not be put on the ballot.
Right. You know, in some cases, in some states, in some elections, they have another line. You have all the candidates, and then you have a line at the bottom that says none of the above. But you can't do that. That doesn't exist for judges in California. Yes.
Here's a less serious question, right?
Okay,
Now this
good.
is Silicon Valley, right? Everybody into technology, startups. It is still a good time for someone to say, I want to go to law school, I want to be an attorney.
Good question.
When does the attorney?
Well, I mean, I think it's more competitive now. So, I mean,
Less opportunity. for
well,
attorneys.
that's another way of putting it. It's going to be harder, depending on how well you do in school, what school you go to, how well you do in school. It may be harder to find a job.
Right, that's what I heard. There are less openings for attorneys because a lot of, for example, merger acquisition, a lot of companies fail. So they have less companies or less paperwork for the lawyers to do.
Yeah. That's the best I can do.
Let's talk about a real case here. Just a week ago, there are 9 students from Arizona State University from China they are forbidden to come to this country, return to the country. So as immigration judges, do you think that is illegal or not? Because this decision should be decided by the university, not by the U.S. custom or the immigration law.
Again,
This is the overrule. This is above the law. Somebody must make that decision above the law.
well, number one, I don't have all the facts of the case. Number two, there are, in the immigration law, there are certain grounds for refusing somebody entry into the country. So I don't know, well, if they were out of status, you know, that might be a reason to exclude them. But beyond that, it's a proper decision for the immigration officers. The university might have its own reasons whether they should attend the school or not, but it's proper for, if somebody is seeking to be admitted to the United States, it's proper for the immigration officer to make a decision. Now, if in those cases, they were entitled to go before a judge, an immigration judge, and make an argue why they should be admitted. Yeah. I mean, so let's say they've been out of the country for years. Well, that's going to be, there's going to be a question as to whether they've, even if they had a green card, there's a question of whether they abandoned their legal status or not. So I just don't have enough facts to answer your question.
I disagree.
If I had more facts, if you had more facts, I might have a different reason.
According to the news, all the nice students are required to purchase the ticket and go back to China. And then they are told to find a lawyer or try to find a way to return to the country or to the universities. So this is not a legal procedure. They are entitled to stay in the United States and find a lawyer.
Let's talk about this question.
That's different. But I think we should do some other studies. What you said is not true.
Yeah.
U.S. Custom officers have really legal power to deny entry to any people.
Yeah.
It's really legal. The action may be unethical, but it is legal.
Yeah, it is.
It's, we should distinguish the difference between legality and ethics. So, unfortunately, there is no easy answer here.
Okay.
All right, we don't have enough facts. Let's move on.
Okay.
Next question.
So, I have one more question.
Question.
Actually, I have two questions, but
Two, always two.
yeah, one more just came to me. There is a retired judge called Richard Posner.
Oh, yeah.
You have heard of him.
Chicago,
He is
yeah.
very famous. And he actually said something that is interesting about his way of judging. Let me read his quote. He said, as a judge, he said, "The first thing you do is ask yourself, forget about the law. What is a sensible resolution to the dispute?" So he will begin with sensibility, just temporarily ignore whatever law or case law or Supreme Court decisions, but just think what is sensible. And then after making a sensible judgment, he would review laws and Supreme Court decisions to see if there is any obstacle to his initial judgment. And if there is any obstacle, he even said usually they can easily be overcome. But nevertheless, his starting point is interesting. He starts from his heart. He doesn't really apply the law by the letter to begin with. He begins with his heart, and secondarily, he will try to use statutes and case laws to decide whether his heart, his gut feeling is correct. So do you think it's very common, and also do you think it's proper?
Well, that is Judge Posner's way of
Yes.
doing things.
Yes. Is it common?
He's not alone.
I see.
He's not alone. It wasn't the way I did it. But I mean, in the end, let's say that's his approach. That's how he does it. Now he's a judge on the Court of Appeals for the Seventh Circuit, so he's pretty far up there. The only court above him is the Supreme Court, and so it would be interesting to see, how often he's been reversed by the Supreme Court. The higher you go, the harder it is to reverse you.
So do you think his approach makes sense, or you are not in favor of his approach?
I said it wasn't the way I did
I
things.
see, but you decline to comment whether it's a good approach.
Let's see, it was a good approach, I would have done it.
I have a related
Okay.
question.
Yeah, you have it.
Okay, fine. Finally, I got a chance to ask my question. This is my time for a while. So in
Here we are.
All right. So in Florida, so there's a famous anti-China senator named Marco Rubio.
Ah, okay.
Yeah. So this guy recently proposed a bill that would prevent Chinese companies, including Huawei, from leveraging a U.S. Legal system to sue U.S. government.
Right.
All right. So I guess my question is, do you think this type of bill or this type of proposal is ethical? Also, do you think the U.S. legal system should be influenced by politics?
Well, I think,
Political reason.
well, let's back up here. Okay, again, I don't know, I think I might have heard about Senator Rubio, but I don't know the details of what the proposal is. I would imagine that part of his proposal turns on national security concerns. And so, I mean, I think it's legitimate, well, in adopting laws to take into account national security concerns. The other thing I would say is that, let's say it gets passed. At least until there's a final decision, it'll be litigated. Somebody will sue, probably Huawei's attorneys, will go to an American court and say it was improper to pass this law. And then it'll go from, up the chain to the Court of Appeals, maybe to the Supreme Court. Wouldn't be surprised if it went if such a case would go to the Supreme Court. But to your other question, should, political concerns affect the legal system?
Always. It's always.
Well,
Always.
yeah, right. Well, I'm thinking, sort of in an abstract sense. Yeah, I mean, the political. Actually, here's another way of looking at it. And this is one of those things. It's difficult. I hesitate sometimes to say it, but judges have opinions like everybody else. Some judges are liberal, some judges are conservative. And when they hear a case, they're going to, these convictions of theirs, which, are just the way they think about things, these convictions are going to affect the decisions they make. So that liberal judges decide cases one way, conservative judges decide cases the other way. So that people, you know, right now, there's a conservative majority on the Supreme
why.
Court.
I think one of the judges decided to go the other way because of the majority conservative.
Well, I mean, it happened, it depends, if the court is closely divided, you have one judge in the middle who becomes the swing vote. And if that judge goes with the conservative, which makes a conservative majority one time and a liberal majority another time, it kind of illustrates the way this works. But it's, in these cases, I think the judges do have, you're talking about judges who have, you know, firm convictions. They have their own, they believe certain things, they have the reasons for believing it, and that's the way they decide their cases. So, in that sense, politics does affect the political, the judicial system. Again, it's not a really clean answer, but it's...
Yeah, it seems that he intentionally would like to close the door to a certain group of organizations or individuals.
Like China, like a communist party,
That
close to the door, VPN, like not allow Facebook, YouTube to go to China. This is
the same
Yeah, I guess at least you should give people a chance to make an argument without it through.
Well, I mean, they will have a chance to make an argument, because let's put it, even though Senator Rubio is proposing this, you know, in Congress, there will probably be people who will argue against this bill for, you know, a variety of reasons. And even if the bill passes, like I say, even if it becomes law, it'll be challenged in the courts, and they'll have a chance, certainly have a chance to argue there. So, you know, it's not like this is going to be passed, you know, like that, and all of a sudden, you know, Huawei's, you know, frozen out of the U.S. market.
Well, but even this case go to the Supreme Court.
Yeah.
But all the half of the judges are assigned by, I mean, they supported the Trump policy, political policy.
Right.
Then how do you know it's fair or not?
Well, remember what I said in the very beginning.
Right.
The Supreme Court is not fallible, not final because it's infallible.
Oh, okay.
It's infallible because it's final.
I know. All right.
That's it. That's the answer to your question.
Okay. Okay.
Yeah.
So it's a political Supreme Court then.
It is.
Well, I mean, all Supreme Courts are political to one extent. You know.
Do you think in general, when you make a judgment of a case, does the order matter more or the justice matter more?
Say it again.
In current legal system, is the order matters more or the justice matter more?
Well, when you say order, what do you mean?
Like you have to maintain the order of the society. You have to keep the justice of this particular, like, both sides.
Well, the goal is that, you know, there shouldn't be a distinction between the two.
But in reality, there is.
Sometimes yes.
Then which one is more important?
And this is a philosophical question.
In your opinion?
In my opinion. I guess I'll go back to the idea of the perfect being the enemy of the good. That I mean, in a perfect world, all decisions will be just and contribute to an orderly society. That's the perfect world. But here's an example. You have cases these days where people have been convicted and spent years in jail, and then the DNA evidence comes out, and they say, "Oops." And so, I mean, the guy, you know, a prisoner might be released after 20 years.
And then they sue, right? And then got millions.
Well, sometimes there's, yeah, I don't know whether they.
Yeah.
Did they sue?
Yeah,
Okay.
some of them sue the
Okay.
state now.
Yeah. Well, or sometimes there are schemes in the state law you know, to compensate them for the time they spent. But again, it's kind of ragged.
Yeah, very often the compensation is very limited and compared to regular lawsuit, they would by law get like $300,000 for 20 years in jail. That would be too little.
Well, yeah, how do you compensate somebody for 20 years in jail?
Yeah.
Oh, sorry, you had a question.
Yes. I just want to ask some sensitive question, maybe around related to your judge. You said you're an immigration lawyer,
Yeah.
a judge, right?
Right.
By your experience or your think about a lot of people applied political asylum, right, in
Yeah.
America. But by my experience, I know a lot of cases, by my personally or by the publishing.
Right.
There are a lot of people perjure and they got the green card from that kind of system.
Mm-hmm.
So how do you think?
Well, I don't approve of it.
What?
I don't think it's a good thing.
Right.
No, I mean.
I just said
no, but here's the thing. Here's the thing. The first thing a judge has to decide is whether the person is telling the truth. Most of the time, if they're telling the truth, you know, it would be easy. But that can be the hardest question. And when the judge makes the decision, there are cases he has to follow, and these cases say the judge can consider A, B, C, D in deciding, we call it credibility. And you know, a judge can't find a person is not credible just because it doesn't feel right. The judge has to be able to explain why he doesn't believe him. And I will tell you, I mean, I had cases where I didn't believe the person. And I told the person I didn't believe him. But I had no choice. You know, I had a case where the guy, there was evidence that he wasn't telling the truth. Well, it wasn't, you know, there was this much wiggle room. And he was shaking. But he wouldn't admit that he wasn't telling the truth. And it wasn't enough for me to say, you're not credible. Does that answer your question?
Good, thank you. So that is just beyond your personal experience, your judge?
That's right. I have to, you know, all judges have to be able to point to concrete reasons for saying a person's not credible. And those reasons, not only do you have to have those reasons, that remember, if they appeal, the court above you has to agree that these are good reasons. And if, you know, there's another appeal beyond that, and the Court of Appeals has to agree there. And, you know, I've had cases where I would see a decision from the Court of Appeals, and I would see there was a certain judge on there, and I said, well, lost that one. Go to the next page, yep, lost it, you know, it was reversed. So, and I don't, you know, I'm not going to say that that judge is corrupt. He just looked at things differently than I do. So, that's the way the system works.
Well, in that case, well, if the person disagrees with the judge's decision,
right,
could he file another application to different judge?
No.
No.
I mean, his recourse is to appeal.
Oh, okay.
Right.
I just made the real thing. I heard my friend told me one guy come to America last year and the normal visa. And when he came to the America, he applied the political asylum.
Yeah.
And in half year, he got the green card. I mean, I don't understand. So, and his reason I heard is he got the problem in China because he is a Christian. But the reality is, but I know he come to America and then baptized in the America church. And his pastor signed that he is a Christian, but he's not. He was in China, he got something by the government. So I think this is totally is perjury. But the immigration judge gave his green card.
Well, I guess he was persuasive. That's the only thing I can say. I mean, if the immigration judge believed him, you know, and he's lying through his teeth.
But he made a story, and maybe his lawyer helped him to make a story.
Well,
and like according you said, the ABCD, there's some reason, so he just fit that reason. But the reality is wrong. It's not true.
For Christian or not, it's not judged by baptism.
What?
So my last question also related to China because we have been talking about China. So Hong Kong now is the hotspot in the world news. So in Hong Kong's judiciary system, from a district court to the final appeal court, most of the judges have a dual citizenship. They are Hong Kong citizen, they are also UK citizen, they are Hong Kong citizen, they are also New Zealand citizens, they are also Canada citizens.
Oh, interesting.
Okay.
Yeah.
So this is a very complicated situation because of the historical reason. Number one question, in US judiciary system, is it allowed for a judge to have dual citizenship? That's number one question. Number two question, if you could give a Chinese government one piece of recommendation or one piece of advice regarding the judge system in Hong Kong, what would that be?
Well, okay, let's do the easy question first. On the question of dual citizenship, you know, I don't know that it makes any difference about the, you know, the decisions the judge makes. You know, yeah, I'm not. That's interesting. It's an interesting situation. You know, the only thing I would say, let's say, you know, the worst case scenario in, you know, things in Hong Kong come to a bad end. Let's say if those judges have dual citizenship and they're not happy, if they can get out, they've got a place to go. I mean, that's my first reaction. They wouldn't have to apply for asylum in the UK or Canada if they have citizenship there. One piece of advice to the Chinese government. Well, I'm not in a very good position to offer advice to the Chinese government. But I mean, you know, I think one of the things that concerns people in Hong Kong is if they're not saying it in so many words, they would say an independent judiciary is very important to them. And that would be, yeah, but I think that's a tall order if, you know, you know, I don't know enough about the Chinese judicial system to have an opinion, really. Because, you know, let's say, the time will come, you know, was it 2047, where, you know, if everything is, you know, the agreement is still in effect by 2047, Hong Kong becomes part of China again. And presumably all of the rules that apply on the mainland will apply in Hong Kong. I mean, it's difficult times ahead. And I don't know how an independent judiciary fits in to that scheme.
Let me add one more comment about the membership of Hong Kong judiciary. In the basic law of Hong Kong SAR, there is one article explicitly saying judges and other members of the judiciary of the Hong Kong SAR shall be chosen on the basis of the judicial and professional qualities and may be recruited from other common law jurisdictions. It's in the basic law.
That's interesting.
Yeah.
Okay, thank you. Okay, well, on that note.